Hello everyone, I am Dr. Simranjeet Kaur, Principal, School of Law, City University, Ludhiana, and in today's lecture we are going to explore one of the most debated ideas in the legal theory, Henry Main's thesis on the movement from the status to contract. This powerful idea has shaped how we understand the development of the private law and the individual rights. But like all theories, it comes with its share of the praise and the criticism. Let's take a closer look. Now let's look at the objective of the lecture. First is to understand the central premises of the main status to the contract thesis. Second is to evaluate the concept of the legal evolution from the fixed social roles to free agreements. Third is to assess the relevance of this theory in today's legal environment. And fourth is to identify both the strengths and the limitation of Main's argument. After this session, you will be able to interpret Main's theory of status and the contract in the context of the legal history, understand its implications for the individual autonomy and the legal system, critically examine both the support and the opposition the theory has received, analyze its relevance in the modern, contractual, and the global legal world. Let's now begin with the topic and see how law shifted from the tradition bound roles to the free contractual relationships. In his seminal in 1861 treatise Ancient Law, English jurist Henry Maine stated that the movement of the progressive society has hitherto been a movement from the status to contract. What Maine meant by the status were the various relational and often hierarchical networks that determined the right and the obligation of the person in the pre-modern society. Pre-modern societies, according to the Maine, were characterized by the various tribal, kinship, and the family relations. These relations specified a person's place in the society, including their prospects of the trade and the marriage. Maine's aphorism has been criticized as oversimplistic, unsupported by the anthropological evidence, and motivated by misguided Victorian beliefs in the linear progress of the socio-culture evaluation. Its truth value in the relation to the modern contract law is nevertheless undeniable. Contract law by the 20th century had come to be based on the liberal principle. Individuals could create rights and obligations with one another regardless of who they were. Yet, the rise of the contract, standardization, and the relational contract theory have since led modern private law scholars to cast doubt on the Main's claim. Their critique goes as follows: people's right and obligation in the modern societies are more so than ever determined by the reference to the personal or the status based attributes. Consumers are increasingly limited in their ability to determine in content of their contracts with the businesses and other commercial actors because they are consumer. Similarly, sociological inquiry into the contractual relationship has shown that the parties' rights and obligations are frequently determined by the non-contractual factors, such as personal relationships between the parties and the respective and hierarchical standing based on the social, political, and economic attributes. It is against the background of this critique that I assess the value of Main's from the status to contract thesis for the modern private law. In part 1, it provides a brief overview of Main's biography and the ideological and intellectual background of his work, paying particular attention to his Victorian ideas about the history and the progress. It set out the Main's journal thesis about the movement from the status to contract. This, I hope, will clarify the specific way in which Maine employed the concept of the status. I also integrate Main's thesis into his more general theory about the nature of the socio-legal evolution. I then address conventional lines of the criticism launched against the Main's theory in part 2. On the one hand, I present the methodological, ideological, and substantive flaws that characterize Maine's ancient law. On the other hand, I show that despite countervailing historical and anthropological evidence, his thesis about the movement from the status to contract has proven remarkably relevant at the same time. I suggest that the true litmus test for the Maine's thesis is whether it has anything interesting to say about the current state or the future of the modern private law. Problematically, scholars have assigned different meanings to the main substantive claims. Status, in the particular, has been subject to the various and frequently inconsistent interpretations. Status today is used in the broader sense than Maine had originally intended. It has come to be understood as encompassing both ascribed and achieved condition. It has also come to be seen as denoting both paternalistic and relational limitation on individuals' capacity to the private autonomously determine their rights and obligations. A considerable amount of conceptual confusion has developed around the main thesis in the recent years. In part 3, I therefore assess whether it's possible to interpret contract, standardization, and relational contract theory into the journal narrative presented in the ancient law. Thus, the argument that modern private law is witnessing a reverse movement from contract to the status have any merit? I go on to show that this revisionist account attributes the shades of meaning to the term status that may never contemplated. Neither standardization nor relational contracting can, with due historical and conceptual accuracy, be described as a modern instance of the status. I therefore dedicate the remainder of the article to exploring why the modern private law scholars, in the face of the clear countervailing evidence, continue to promote mean status speak and remain from the status to the contract. Biography and historical background, as is the case with the many extraordinary thinkers, main scholarly achievement are inextricably interwoven with his own life story and this social political currents of his time. For the reason, the following section integrates Maine's thesis about the movement from the status to contract with his biography as well as with the ideas and prevalent in the Victorian England. Henry James Sumner Maine was born in Kelso, Roxburghshire in 1822 after studying the classics of the Pembroke College, Cambridge. He became the tutor of the Roman law Trinity College, Cambridge. At the age of 25, he was appointed Regius Professor of Civil Law shortly after in 1852. Maine was additionally appointed as a reader in the Innis Court in the London. At around the same time, he began the working on a manuscript about the historical development of the law in the ancient world. Parts of the ancient law were in fact first set out as the lectures delivered in the London's Middle Temple, influenced by the German historical school and critical of the practice orientation of the legal education at the time. Maine's aim was to revive jurisprudence as a comparative, historical, and the philosophical discipline. Upon its publication in 1861, Ancient Law, according to Howell, the preeminent work on the origin and the nature of the primitive legal institution, was received to wide acclaim. To no small extent, this was due to the fact that Maine's project, the reconstruction of the historical origin and the logic of the particular socio-legal institution, vindicated the individualistic and the forward-looking tendency in the Victorian politics, philosophy, and economics. Particularly, Maine's argument about the evolutionary logic of the history was met with enthusiasm similar to that inspired by the Darwin's theory of biological evolution. Darwin on the Origin of the Species was published 2 years before the Ancient Law by the same publishing house. There is a good chance that Maine was influenced by this work or at least considered himself to be the writing in the same tradition. Maine's principal argument concerned the development of the primitive to the progressive society. Ancient law covered the early history of the wills, property, contract, criminal law with regard to each. Main emphasized the contrast between the family and the individual as the basic unit of which the law took account. The main thesis advanced in the ancient law, if not the manifesto of his life work, was that the progressive society had moved from status to contract. In modern society, individual rights and the obligations had come to be created through contracts, being and embodying the modern ideas like liberty and individualism. Not so far individual rights and the obligation. In predominant society, according to Maine, the particular place into which an individual had been born as a part of the given family or kinship group exhaustively determined that individual's legal standing, their prospects of the trade and marriage, and the entitlement to decide what happened to their property after death. To Maine, enhanced moral consciousness was behind the increasing contractual freedom in progressive societies. For this reason, the only people whose rights and obligations ought to be fixed according to their status were to be those that do not possess the faculty of forming a judgment on their own interest. Maine's journal thesis, having taken a brief look on defining stages of Maine's scholarly life, amongst which he defines as a classicist his position as the Anglo-Indian administrator and his role as a critical examiner of Victorian society are most notable. It is now necessary to analyze in detail the substantive claim at the root of his continuing intellectual significance. As my discussion up until this point has shown, Maine's thesis about the movement of the progressive society rests on his particular concept of status, his notion of the ancient family, and his more general theory about the nature of the social legal evaluation. The multiple meanings of the status, as noted by the Pollock in his commentary on the ancient law, means reference to the status can mean three different things. Status may refer to the totality of the person's right and the obligation. It may also refer to someone's personal rights and the obligation being a minor or a implicit as opposed to their proprietary relations, being a tenant or an agent. Finally, it may refer to the rights and the obligations imposed upon a person by the law and without his or her consent instead of voluntarily and by way of agreement. The many meanings of the status have led to the widespread acceptance of Maine's theoretical masterpiece. At the same time, they have separated his claim from the particular point he was trying to make. The conceptual multivalence of the status obscures the value of Maine's thesis for the modern private law. Smelly suggested that Maine was concerned only with the third meaning of the status. His generalization thus meant little more than that in the Hofheddian terms disabilities of the subordinate members in the patriarchal family had gradually been eroded in the favor of the powers created by the way of consensual contracts. What Maine really intended with his juxtaposition of the status and the contract had been to draw attention to the contrast between the primitive and collectivism and progressive individualism, those parts of the ancient law dedicated to the topics other than contract support this argument. Maine employed this comparative historical methods to trace the development of the various modern institutions. With regard to the each one, he emphasized the move from collectivist to the individualistic. Rationals may argue that passing on property to the bestow individuals material wealth or one's own descendant constituted a relatively modern phenomenon. The functions of the will in the ancient society had instead been to allocate collective management responsibility to the new heads of the family. Similarly, in the area of the property law, men trace the movement from the joint communal ownership structures, characteristics of the primitive society to the individual land ownership in the later times. Finally, he explained the relative abundance of the criminal provisions in the primitive society by contrast to the relative scarcity of the provisions of dealing with the private law matters. Due to the fact that individuals' right and the obligation had exhaustively been determined by their position in the ancient family, there was no need to include authoritative standards of the private conduct in any of the ancient codes he examined. Maine's notion of the family, Maine's notion of the status, hinged on his vision of the ancient family. What Maine meant by the family, however, had little to do with the modern natural or the nuclear family. Instead, it encompassed a host of partly effective relations of the kinship and the power. Maine's idea of the patriarchal family was influenced by the Roman notion of patria potestas. More specifically, he based his analysis of the various socio legal institutions on the presumption that ancient societies had consisted of the communities of the family, each of which was headed by the male patriarchal who possessed theoretical unlimited power over its members. Maine's argument then was that the transformation from primitive to the progressive society had uniformly been characterized by the gradual dissolution of the family dependency and the growth of the individual's obligation in its place. As a consequence, the individual had steadily been substituted for the family as the unit of which civil laws take account. This observation led him to formulate his famous conclusion that the movement of the progressive society has hitherto been a movement from the status to contract. As we will see, it is this particular understanding of the family that has made Maine's theory vulnerable to both methodological and substantive criticism. Maine's journal theory of the socio-legal evaluation, Maine himself substantively qualified his thesis about the movement from status to contract. Notably, he achieved the qualification through the word "hitherto," which has given rise to considerable speculation over the time. Burrow argued that Maine's reference to his historical specifically to the movement from the status to contract evoked a certain moral polarity. Maine may have perceived some higher state of moral or civilizational development to be attached to contract. There is thus an arguable connection between the recognition of the individual liberty in theory and allowing people to autonomously determine the architecture of their own fate by way of their consensual contracts in the practice. Fewer in the turn interpreted hitherto a true qualification to the main thesis in view of the late 19th century British politics. Maine refrained from extending his use of the word status to the rise of the democratic legislation. He was nevertheless acutely aware of increasingly limits placed on the contracts during his lifetime. First introduced in ancient law and brought to the conclusion in the popular government, Maine observed a second phenomena in the transformation from the primitive to the progressive society. This was the movement from the strict adherence to the primitive code to amending and improving that code, first by way of the legal fiction, then by way of an equitable principle, and finally by way of the legislation. How if at all, is this movement related to the movement from the status to contract? Maine does not state explicitly that how the two might fit together. Critical perspective on the Maine's thesis. More than half a century ago, Stone observed that scarcity of the Maine's hypothesis has come unscattered through the ordeal of the later research. This assessment has not lost any of its pertinence. Maine's thesis about the movement from the status to contract is liable to the methodological, ideological, and substantive criticism. Nevertheless, his thesis has proven remarkably relevant over the time. Methodological criticism. Despite the praise that Mainz initially received for the ancient law, critics have since identified his method as flawed. They have focused in the particular on the abstract nature of his thesis, his reliance on the materials from the culturally and developmentally similar societies, and his emphasis on the communal rather than individual conception of the pre-modern identity. Main's conceptual categories constitute ideal types. As such, they are subject to the journal criticism. This typological term has generated Main himself realized the danger of abstracting too far from that particular, stating that generalization consists in dropping out of the sight a certain number of the particular facts and constructing a formula which will embrace the remainder. To be sure, not intellectual endeavor can entirely discipline with the generalization and the other organizing principles. Main's exclusion of the particular facts, however, has made it particularly easy for the critics to argue in favor of the limited applicability of his claim. Ideological criticism. Maine was very much a man of his day. He wrote for a particular audience and with a particular purpose in mind. Given Victorian preoccupations with the progress, culture, and the history, ancient laws celebrate the dual English foundational myth of the liberty and individualism as manifested in the private property and the freedom of the contract. Maine sought to weave together the histories of the various branches of the Aryan tree into a continuous institutional history of the progressive development of the private property, freedom of the contract, and the individual right. He did this with a clear mind to reinforcing contemporary hierarchical ideas about the race and the culture. Maine's comparative historical method was imbued with the form of patronizing Victorian evolutionism and motivated by the modern conservative view of the human nature and a vigorous anti-liberal assault. As laid down above, Maine took a gradually more active role in criticizing the direction that Victorian politics was taking. He became increasingly skeptical about the democratic legislation as a tool for the social regulation and the reform, with his emphasis on the contract as a relatively recent civilizational achievement. Maine positioned himself directly against the contraction theory of the Locke, Hobbes, and the Rousseau, as well as against the utilitarian theories of the Austin, Bentham, Maine considered these theories to be unhistorical because they presuppose the status of the nature had been overcome either through social contract or the instatement of a command issuing sovereign. He was particularly concerned that Locke, Hobbes, Rousseau, Austin, and Bentham all ignored custom as a tool for the expression of the social change. Substantive criticism. Much of the substantive criticism leveled against the Main's thesis hints on the historical and anthropological evidence that was unavailable during his lifetime. As such, it is not entirely fair. Atiyah emphasized that Maine was writing at a time when it seemed that modern society was indeed moving in a linear fashion from the status to the contract. Similarly, Cohen suggested that Maine's thesis could easily be documented based on the Indian materials. A balanced analysis of the Maine's thesis nevertheless required critical engagement with the countervailing historical and anthropological evidence. In addition to substantive implication of the Maine's particular methodological and ideological comments, it is especially his notion of the pre-modern family that leaves the ancient law vulnerable to the criticism. Maine had based his idea of the patriarchal family on the Roman legal sources, while the extent to which the concept of the patria potestas holds any historical credence has been called into the question. There was even then little reason to think that the original socio-political organization of the civilized society was that of the patriarchal family. In 1861, the same year, ancient law has published, the Swiss legal anthropologist John Behofen published Das Matrecht, Mother of the Law, the Mother Right, analyzing the religious and juridical character of the matriarchy in the ancient world. Backhofen arrived at the conclusion that the many pre-modern societies had been based on the matrilineal rather than the patrilineal descent, with the mothers and the women of the household occupying a particular place of the authority and the respect. Similarly, Redfield argued that an emphasis on one line of descent rather than the other was characterized of relatively advanced society. Only he forcibly conclude that there is no reason to suppose that Eskimos ever lived in patriarchal societies. In concluding remarks, Maine's theory provides the compelling narrative of the legal progress. While it has faced criticism for being too linear or simplistic, it still offers a meaningful framework to understand the shift from the hierarchical structure to the individual legal autonomy. Has Main thesis gained prominence more for its theoretical stint than for its empirical accuracy? Scholars have raised this question, pointing to the several concerns. Main's tendency to generalize, such as equating primitive law with the ancient legal system, and his broad assumptions about the structure of the pre-modern families have led many to the questions that reliability of his conclusions. Stone notably remarked that few of the Main's hypotheses have withstood the scrutiny of the subsequent research. Interestingly, Maine himself seemed aware of the limitation of his own thesis. In his later work, his observation did not always align with the famous claim that society evolves from the status to contract. For instance, his study of the feudal land tenure revealed that contract law played a significant and pervasive role, so much so that, as Pollock and Maitland noted, the law of contract threatened to swallow up all the public law despite these inconsistencies. Maine's broader generalization has endured. In 1950, Redfield observed that broad sweep of the human history, particularly the evolution of the European society and the transformation of the tribal communities through external contract, journal support. Maine's perspective today, the status to contract framework remains a foundational concept in both social theory and the study of the private law, regularly cited in the legal anthropological literature alike. Thank you for being the part of this thoughtful discussion. As a future legal minds, remember, law does not just shape the society, society shapes the law too. Main works remind us to look deeper into the legal systems, questions their roots, and think critically about where we are headed next. I am Dr. Simranjeet Kaur, and I'll meet you again soon. Until then, stay engaged, stay reflective, and keep growing with the law. Thank you.